Hello, Enoch here again. My name is Enoch and I will be taking commercial transactions, and our topic that we're going to be treating throughout this session basically is sale of goods. Sale of goods. Sale of goods is a very broad topic. It has many subtopics underneath it, all the way from the definition, the general introduction, the types, all the way to transfer of risk and property and so on. But in this module, we're just going to be dealing with the introduction, the definition of sale of goods, and types of goods. So, yeah. The thing is that sale of goods is a topic governed by an act. It has an act. It is a body of law that is governed primarily by an act and not just only case law. And the act is the Sale of Goods Act of 1893. The Sale of Goods Act of 1893, also called SOGA. We usually call it SOGA, S-O-G-A. Aha. So the act defines sale of goods. Section 1 of the act defines sale of goods as a contract whereby the seller transfers or agrees to transfer property in goods to the buyer for a money consideration called the price. I'm going to say that again for those of you, and please try and get a copy of the Sale of Goods Act to follow. A sale of goods as a contract whereby the seller transfers or agrees to transfer the property in goods to the buyer for a money consideration called the price. Now, the definition of sale of goods is very important because it has some basic elements that are present in it that are required before a contract can be called a sale of goods. One, there must be a seller. There must be a seller. There must be a definite seller with the title to the goods. There must be a transfer of property, and we know that in law courses usually we have to be careful about the words we use. In this case, we said property, not possession, meaning that we're saying property in the sense of ownership, in the sense of title to said goods and co. There must be a buyer. There must be a money consideration. Going by this definition, or by the implied terms of this definition, that there must be a money consideration, we can then assume that, yes, that any sale of goods transaction where there is no money consideration involved, it cannot be defined or termed to be a sale of goods. I'm going to go through that again. That for a contract to be considered a sale of goods, there must be money consideration involved. It is also possible for it to be partly money and then partly goods, partly money and partly something else given in consideration, but money must be involved. You can't just do exchange of goods for goods and then call it a sale of goods. No, the Act does not allow that because it does not fall within the definition as given by the Sale of Goods Act of 1893, Section 1. And I would also like to note that some states also have their sale of goods law, which are also applicable. States like Lagos State that has its own a sale of goods law of 2015. It's a bit more comprehensive in some areas than the Sale of Goods Act, but more or less they are in agreement on some basic things like this definition. Okay. In Section 61 sub 2 of the Sale of Goods Act, it is also stated that since the Act is not exhaustive on sale of goods transaction, because it's not possible for just one single statute to cover all aspects of normal everyday transactions that we do, you buy, we sell and stuff like that. It's not possible for one statute to just codify everything. So therefore, the Act goes on to say in Section 61 sub 2 that the general principles of common law of contract also apply, insofar as they are not inconsistent with the provisions of the statutes. Meaning that we are not going to throw away our previous knowledge on contract, we're not going to throw away our common knowledge on transactions. It's just that they have to be in line with the stipulations of the Sale of Goods Act of 1893. That's what it provides for in Section 61 sub 2. Now I've defined what sale of goods is as defined by Section 1. Now there is a distinction made by the Sale of Goods Act in Section 1 sub 3 between a sale of goods, a contract for the sale of goods, and an agreement to sell. They sound similar, but they're different, and I'll tell you why. A contract of sale, as the distinction has been made in Section 1 sub 3, is one that involves passing of property and the payment in price. The payment in price can be at that moment, but basically involves the passing of property immediately. That we have conducted the sale, I have bought something from you, and then the sale occurs immediately. While an agreement to sell involves the passing of property, that there will be a passing of property at a later date. That, oh, perhaps me and you, we have an agreement that, oh, I'm going to buy these wonderful t-shirts from you, but I'm not going to buy it now. That I'm going to come and buy it from you tomorrow. We have an agreement to sell, but it is not a contract of sale yet. There's a slight distinction, but the difference is important. And as we go on into sale of goods, you will learn that yes, there are important reasons for these distinctions. In section 1 sub 4 of the Sale of Goods Act, it also gives conditions under which an agreement to sell will become a contract of sale. Like I said, sale of goods is a topic that is very, very deeply entrenched in statutory law. That's why we keep on quoting the Sale of Goods Act a lot. Okay, so section 1 sub 4 says that when the time elapses or conditions are fulfilled subject to which property is to be transferred, an agreement to sell becomes a sale of goods, a contract for the sale of goods. I'll take that again. That when time elapses or conditions are fulfilled subject to which property is to be transferred, an agreement to sell becomes a contract for the sale of goods. Meaning that, oh, if we have an agreement to sell, when exactly does that agreement to sell become a contract for the sale of goods? Either when enough time elapses that you've been with the goods for a while, even though that you've not paid and everything, but you've been with them for a while. Time has elapsed. Automatically becomes a contract for the sale of goods. Or conditions are fulfilled, conditions that we stated out in the agreement to sell, that, oh, I will not buy this from you until this is done. And when you have done that, automatically the agreement to sell becomes a contract for the sale of goods. It's straightforward. Okay, now there's something very important that the foundation we need to lay down now, is that in the definition given before in section 1 sub 1, the subject matter of a contract for the sale of goods has to be goods. The subject matter has to be goods. That's why they call it sale of goods here. The subject matter has to be goods, and the Act goes on to define goods in section 62 of the Sale of Goods Act. Section 62 of the Sale of Goods Act. That goods can be defined as all chattels personal other than choses in action and money. That's the first part of the definition, and I'm going to start with that. All chattels personal other than choses in action and money. What are chattels personal? Things that can be owned personally, things that you can own, things you can touch, things you can like physically possess. All chattels personal. A shoe, a car, chattels personal. It said other than choses in action and money, meaning that you can't say you are selling money in a contract of sale of goods. It's ludicrous in a way. You can't sell money unless there is an exception though. Unless in situations where said money or currency has become something like a curio piece. And what I mean curio piece, maybe something like old currency or so, maybe an antiquity, something of, but the value has changed from just being just mere money alone. And he said, all chattels personal other than choses in action and money. Choses in action are intangible goods, goods that you actually need to maybe like have a legal document or so to enforce their ownership. Like now, shares are choses in action. You can own shares, but you can't physically hold them. So, definition of goods, all chattels personal other than choses in action and money. It also includes implements. Implements are crops which don't grow naturally. They are a result of agricultural labor. That's what we call implements. They grow annually. Implements. They are crops like your maize and co. That grow on an annual basis. They don't just sprout up on their own usually. They're a result of agricultural labor. They can be considered as goods. Industrial growing crops, yes, that's also included in the definition of goods. We call those ones fructus industrialis. Fructus industrialis. Yeah. They also don't grow naturally. They take like 2 years or more to grow. The Act is basically trying to be as exhaustive as possible with the definition of what it considers to be goods. That's why it's going through all of this. And then also includes things attached to and forming parts of the land. We call that fructus naturalis. Things attached to and forming parts of the land, which are agreed to be severed and / removed from the land. Now, I will explain that part. Things forming or attached to part of the land and which are agreed to be severed or removed from the land. We call those ones fructus naturalis. These ones occur naturally. They are there on their own. Things that are attached to and form part of the land. That could be minerals. It can be a piece of gold. It can be a piece of diamond. It can be crops, things that just grow on their own. But the Act says that they will not be considered goods unless they are severed or removed from the land. That there is an agreement between both the parties, the buyer and the seller, that at the time of sale, they will be removed from the land. So it doesn't come under the Sale of Goods Act until that is done. It doesn't come under the Sale of Goods Act until both parties agree for that to be done. So that's the definition. We've gone through the definition of sale of goods, we've gone through the definition of goods, and now we're going to move to the types of goods. So we have three main types of goods. Don't worry, the distinctions might seem confusing at first, but they're actually more straightforward. The first type are specific goods under section 62 sub 1 of SOGA, section 62 sub 1 of SOGA. SOGA means Sale of Goods Act. I'll be saying that a lot because it becomes tiring to say Sale of Goods Act again and again. So it defines specific goods as goods identified and agreed upon at the time of sale. That you identified them and that you have agreed upon them that yes, these are the goods that I want. So it's not that they were described to you or something like that. And we have a case underneath this called Ajayi versus Alice Ebon. Ajayi and Alice Ebon, in which the High Court held that the goods in question, it was a case involving trinkets sold as gold, that the goods in question were specific, not unascertained. It's a very funny case, actually. They were that the goods in question were specific goods because they're trinkets, not unascertained. Second types of goods are ascertained goods. The Act does not expressly define this, but they are generally accepted to be goods identified by parties in accordance with the agreement after the contract is made. They are goods that are identified by the parties in accordance with the agreement after the contract is made. The difference between specific goods and ascertained goods is the time of identification. Time of identification for specific goods is at the time of making the contract, while for ascertained goods is after the making of the contract. And then we have third one, unascertained goods. These are goods that are sold by way of description. They haven't been specifically identified or agreed upon. And there are three categories of them. There are generic goods that have they're general, like bottles of drinks. There's no distinction between them. Sale of part of a whole, like maybe if you go to a place where they sell bags of rice and you ask them that, you want to buy bags of rice. It's not as though you're talking about specific bags of rice. Those are unascertained goods. And sale of future goods to be manufactured in the future, acquired by the seller. So in this module, we have tried to cover the definition of sale of goods as given by Section 1 of the Sale of Goods Act of 1893. We have touched on the definition of goods as given by Section 62, I believe. Yeah, Section 62 of the Sale of Goods Act. We have tried to touch on the types of goods, and I'm going to end with this. We have mentioned unascertained goods. We have mentioned that, there are goods that have not been seen by the buyer and co like that. So how then do you buy what you've not seen? There's a category called sale by description, Section 13. We have existing Section 13, that there's an implied condition that the goods must correspond with the description. And there are also two other types of goods that are usually not touched upon, but yeah, they are existing goods. Goods owned and possessed by the owners at the time of the sale, and future goods to be manufactured by the seller at a future date. I hope that this has been educative and illustrative. So please, I would like you to come with us again next time as we go into the distinction of sale of goods, distinction between sale of goods and other types of contracts and so on. So please subscribe to this channel. We have amazing content. That's actually the truth of the matter. We try as much as possible to break down things that lecturers don't really take much time on. We try to bring them to your level, to our level, because we also are students. We feel the burden. So please subscribe to this channel, share with your friends, comment so that you can learn more about commercial transactions from me, Enoch, and I'm going to try my best not to disappoint you. Thank you.